Slavery, or the de facto American caste system, was effectively abolished at the end of the U.S. Civil War. In 1865, the 13th Amendment to the U.S. Constitution superseded or negated prior 1788 Article 1, Section 2, 3/5 Clause. But both entries can still be found in our Constitution since former terms can never be removed. More importantly, now that Black American slaves are freed and no longer legal property, follow-up 14th Amendment granted these ex-slaves born on American soil U.S. birthright citizenship. And here exemplify the great question of that era. The 14th Amendment explicitly gave ex-Black American slaves citizenship. But what about other natural-born Americans, be it Caucasian, Asian, Native American, or other races? What about them? That was a legal gauntlet placed before the U.S. Supreme Court in 1898. Because if Wong Kim Ark lost this case, that means the U.S. Congress at a legislative whim, or even the U.S. President at stroke of an executive order, can unilaterally define how American-ness you are to be a citizen, regardless of your natural birth in the U.S. Now, we are not just talking about racial sentiments against Chinese, but also future cases against Americans of Japanese, German, Italian heritage of the like. Via this logic, one can easily assert because you like Korean dosu bibimbap, or drink too much Vietnamese nuoc mam, or even eat too much Texas barbecue ribs, then you can never legally be an American citizen because that practice was against mainstream American social norms. Not to mention, are you too German, too Polish, too Scot-Irish to be American because you cling too much to your ancestral culture? Or even better, are you too Catholic, too Buddhist, too Hinduist to be American? Well, you get the gist.